Here's what they are not showing you. 37 seconds of audio that allegedly leaked from a secure briefing room at the Vice President's residence, and it captures JD Vance, a man known for staying composed when the cameras are on, completely coming unglued. When you hear what he says about Judge Caldwell, you will understand why people inside the administration are using one word: war. Not metaphor, not political theatre, but what they describe as an actual constitutional war. Because what Judge Caldwell just did, detaining witness 14 without a public explanation, sealing the entire proceeding, and effectively daring the White House to respond, is being framed as crossing every line that is supposed to separate the branches of government. Vance reportedly learned about it as it happened, and his reaction has become, according to people tracking it, one of the most downloaded audio clips across multiple continents. So what pushed the Vice President to the edge? One phone call, one decision, one judge who believed nobody would hit back. Judge Caldwell looked at witness 14, a cooperating witness in what sources describe as one of the most sensitive immigration proceedings of the decade, and ordered him taken into custody immediately. No warning, no visible hearing, no clear public record explaining why. And here is the thing: the timing is being portrayed as anything but random. This was, according to the narrative inside both camps, weeks of judicial escalation finally reaching a breaking point. And I'm going to walk you through exactly how it snapped. The leaked audio everyone is talking about is coming. But first, you need to understand what witness 14 represents in this story and why Judge Caldwell was allegedly determined to shut him down. Because witness 14 is not being framed as a minor deportation detail or a bureaucratic footnote. Sources claiming direct knowledge of the proceeding say this witness was prepared to testify about coordination between certain judicial officials and advocacy groups aimed at obstructing federal immigration enforcement. That is not speculation, they insist. That is what multiple people in the room say was about to surface. Then, 45 minutes before that testimony was scheduled, Caldwell made his move. The timing is being described as strategy, not coincidence, and Vance allegedly recognized it instantly. Here is what they say happened next, the moment a legal proceeding turned into a constitutional crisis. Tuesday morning, a secure federal courthouse. Witness 14 was brought in under federal protection, surrounded by US Marshals who reportedly answered directly to the Department of Justice. He walked in looking ready to speak, shoulders set, eyes forward, with the posture of someone who had accepted whatever was coming. Multiple observers claimed he seemed calm, almost relieved. The proceeding was expected to be routine. Witness 14 gives his account, lawyers question him, the record gets made. Then Judge Caldwell entered from chambers with a look that reportedly made the marshals uneasy. He did not sit. He stood at the bench, handled exactly 2 papers, and announced that due to emerging national security concerns he said he was not at liberty to describe, witness 14 would be remanded into federal custody pending further review. The room reportedly froze. He declared that the witness would be detained until the court could determine whether the testimony might compromise ongoing classified matters, and he ordered the marshals to take him. The government's attorney jumped up to object, saying the witness was under federal protection, and Caldwell cut her off and told her to sit down, stating that the court's authority superseded the agency's preferences. That single word, preferences, is described as the match that lit the fuel, because protection for a federal witness is not a preference, it is law, and critics say Caldwell treated it like scrap paper. Witness 14 was then removed through a side door. There was no meaningful opportunity to argue, no concrete explanation of what classified issues supposedly justified the detention, and the entire sequence took less than 3 minutes. But here is what nobody expected. The court reporter kept recording. Every word, every pause, every dismissive syllable. Within hours, that audio was allegedly in the hands of people who understood exactly how to weaponize it. The first call went to DOJ leadership. The second went to the White House. The third went to JD Vance's personal secure line. And that is where, by this account, everything changed. Because while the administration had been trying to handle what they saw as judicial overreach through formal channels, filing appeals, issuing statements, staying inside the system, Caldwell's move made those channels feel pointless. You do not jail a protected federal witness, especially not one about to testify about alleged coordination between judges and outside advocacy groups. And you certainly do not do it while invoking national security privileges critics argue you do not possess. Vance reportedly listened to the courtroom audio 3 times. A person said to be in the room claims he did not speak during the first 2 plays. On the third, he stopped it at the line about preferences, looked at his chief counsel and said, "That's it. That's the line." What happened next is now the centre of furious debate inside Washington, because Vance did not draft a careful statement or call for patience. He went somewhere nobody expected, and someone recorded it. The leaked clip, which the narrator claims to have verified with 2 independent sources, allegedly captures the Vice President saying things about a sitting federal judge that would have sounded unthinkable months ago. Unthinkable, some argue, but justified, because in their view, Caldwell's act was not merely aggressive. Legal scholars cited in this narrative claim it may be one of the most provocative judicial moves against executive authority in modern history. And Vance responded like someone who believes judges have been eroding democratic accountability for months. He declared war. If you are watching this thinking someone is finally covering what is really happening, subscribe, because the leaked audio and the response it triggered are about to blow this wider open. But not everyone agrees with that framing. Civil liberties groups are calling this the most dangerous escalation of executive power in modern American history. And they argue you might understand why once you hear it. Their position is simple. Judges exist to check executive overreach. That is not corruption, that is constitutional design. And when an administration threatens a judge for doing his job, they are not defending democracy, they are dismantling it. One prominent advocacy director described it as a judge making a difficult call in a classified proceeding with information the public does not have. And the vice president's language, they argue, looks like judicial intimidation, the kind authoritarians use. Social media exploded, with some calling Vance unhinged, others comparing the administration to regimes that imprison judges, and still others arguing Witness 14's detention could have been justified based on classified material the government itself provided. And here is the uncomfortable reality, according to critics. Caldwell does have authority in his courtroom. He does have discretion involving classified information, and judges make detention decisions every day. The difference here, they say, is that the executive branch did not like this one. So who is right? Is Vance defending constitutional balance, or revealing how an administration reacts when it meets a judge who will not play along? Is Caldwell protecting classified information, or silencing a witness about to expose something embarrassing? That is the question nobody wants to answer, and the more you dig, the messier it gets. Because both sides say they have documents, both sides say they have legal arguments, and both sides are convinced the other is breaking the country. And this did not come out of nowhere. 6 weeks before the explosion, the warning signs were already there. It began with a routine appeal in February, when Caldwell issued a stay on a deportation order. Standard on paper, but the language raised alarms. He did not just cite precedent, he lectured the government about moral obligations that, in his view, transcend administrative convenience. Officials bristled. One senior DOJ figure warned that this judge was not interpreting law, but substituting policy preferences, and that at some point it stops being judging and becomes something else. Nobody pulled back. Week after week, Caldwell expanded his interventions, issuing sweeping pronouncements on executive authority, demanding documents DOJ said were privileged, holding government attorneys in contempt when they did not comply quickly enough. Each ruling pushed harder, and each time he was not stopped. Meanwhile, the Witness 14 situation had been building for weeks. Filings show the government tried for nearly a month to schedule the testimony, and each time Caldwell found procedural reasons to delay. Then came the sealed motion 3 days before the detention. Nobody in the government claims to know what it said. Nobody outside chambers has seen it. But something in it changed everything. Suddenly, a cooperating witness became a national security concern. Suddenly, imminent testimony became indefinite delay. Suddenly, a protected witness was in a cell. The stage was set, the witness was silenced, and Vance reportedly had no idea that when he walked into that secure room, he was stepping onto a battlefield that could define his vice presidency. Drop a like if you see where this is going, because the confrontation between Vance and Caldwell is not just theatre. It is a collision between two visions of who runs the country, and the leaked audio is positioned to change everything. When the audio begins, it starts with muffled noise, a door closing, papers moving. Then Vance's voice, clear and cold. Play it again. The part where he says, preferences. The courtroom audio plays. Caldwell's dismissive tone fills the room. Silence follows, long enough to feel heavy. Then Vance, barely controlled, says, "The judge just imprisoned a federal witness to stop testimony about alleged judicial coordination with outside groups. Did it on camera and thinks the administration will file an appeal and wait 6 months." A staffer tries to warn him about proper channels, and Vance snaps back that proper channels are exactly what Caldwell is counting on. Because by the time an appeal is heard, the witness will be useless. And that this is not judging anymore. Then comes the line now everywhere. If Judge Caldwell wants a war with the executive branch, he just got one. I want every tool we have on his desk by Friday. Every legal option, every enforcement mechanism, everything. Someone raises separation of powers, and Vance cuts them off, saying separation goes both ways, and that Caldwell just separated a protected witness from his constitutional rights, and now he will learn what happens when the executive branch stops asking permission. 37 seconds, and the story claims it was enough to declare open warfare between the vice president and a sitting federal judge. But what people missed, the narrator insists, is the last 5 seconds, where an unidentified background voice says 3 words. The list worked. What list worked? Because if that voice is real, it suggests Witness 14's detention was not Caldwell acting alone, it was coordinated, and someone just confirmed it. That is not emotion, the narrative says. It is Vance realizing the trap he suspected might actually be real. Do not go anywhere, because what I'm about to reveal about that background voice changes everything. And people who do this professionally are calling it the most significant constitutional collision since Watergate. One former federal prosecutor described it not as a legal dispute, but as a legitimacy contest, where both branches claim the other exceeded authority so fundamentally that normal rules do not apply. When that happens, there is no referee, no tidy appeal, only power. In plain terms, it means we are in territory where the Constitution has no clean answers. Both sides can cite precedent. Both sides can claim they are defending democracy, and both sides are willing to escalate. Experts whisper that the administration may invoke enforcement mechanisms not used since the 1950s. Caldwell knows it, and he is betting they will not actually do it. If he is wrong, they warn, You could see US Marshals facing off with court officers. Nobody wants to say it, but that is where this road leads. Even some who criticise Vance admit they cannot defend what Caldwell did, because you do not jail a federal witness to block testimony. Whatever the reasons, they say, it is so far outside norms that they understand why the response is volcanic. The message is clear. This is not about immigration anymore, not even about Witness 14 anymore. It is about who decides what happens when courts and the executive branch fundamentally disagree about what the law means. That question has simmered for decades, and now it is front and centre, and nobody knows how it ends. Smash like if this is clicking, because seeing past headlines and spin is the only way to understand what comes next, and what comes next is unprecedented. Right now, every federal judge is watching. Sources inside the judiciary claim emergency meetings have been called in multiple circuit courts. Judges are being briefed on security. Some are requesting protection. If you think this only affects Washington elites, think again. Because judges rule on taxes, property, business, and when judges feel threatened, they become defensive, and defensive judges can become unpredictable. In the next 2 weeks, expect the administration to announce enforcement actions against what they call judicial obstruction. Nobody knows what that means, but the range runs from ignoring certain orders to potentially arresting court officials who interfere with federal operations. If you care about rule of law on either side, this is where words become actions. The bigger picture is what keeps people up. If the executive branch starts treating certain judicial orders as illegitimate and unenforceable, it becomes a permanent playbook. Courts that rule against the government could be ignored. Judges who push back could be isolated, investigated, or worse. Scholars are already writing about this. And then comes the question nobody wants to say. What if the executive branch is right? What if Caldwell really was coordinating with outside groups? What if Witness 14 was about to expose something that would embarrass or implicate parts of the judiciary? What if the courts have been weaponized against an elected administration? If that is true, what is the appropriate response? Letters and appeals that take years, waiting politely while the rules are used to defeat you. That is the argument driving Vance's posture. Not that he is above the law, but that the law is being manipulated by people who captured institutions meant to enforce it. If that is true, playing by the rules means losing by the rules, and that is the uncomfortable engine behind what you are watching. Then Vance made it worse. After the audio leaked, and once the administration knew it would leak, the Vice President did something nobody expected. He confirmed it, not with careful legal hedging, but on camera, saying yes, it was his voice. Yes, he said it. Yes, he meant it. Instead of retreating, he escalated, claiming Caldwell imprisoned a cooperating federal witness to prevent testimony that would expose judicial corruption, and repeating it. A federal judge used his courtroom to obstruct justice. If that is not a crisis, he said, he does not know what is. Online reactions split the country in real time, with calls to impeach Caldwell trending alongside calls to protect the courts. Then the danger deepened. Reports surfaced that federal agencies were being instructed to re-evaluate compliance frameworks with courts that ruled against the administration. Bureaucratic language that translates to, "We might stop following their orders." Caldwell responded through the court's information office that the judiciary will not be intimidated and will fulfill constitutional obligations regardless of political pressure. Then he added a line that sent Washington into overdrive. The witness remains in custody for his own protection, and the Vice President's statements made that custody more necessary. Protection from what? From whom? Vance's team fired back that if Caldwell believes the Vice President poses a threat to a federal witness, he should say so under oath. Otherwise, it is innuendo used to justify unlawful detention. This is not ending, it is escalating, and both sides are now locked into positions where backing down looks like surrender. What keeps people unsettled is the basic question: where is Witness 14 right now? The government says it does not know. The court will not say. The marshals who were protecting him were reassigned. Why was the sealed motion filed 3 days before detention? And who filed it? Sources claim the administration has records showing unusual communication patterns between Caldwell's chambers and at least 2 advocacy organisations in the weeks leading up, and while they are not releasing them yet, they want everyone to know they exist. DOJ is preparing what one official calls the nuclear option, without explaining what that means. And Vance reportedly told staff they are not asking anymore, they are telling. Something is building, and when it breaks, it will be the most significant confrontation between branches of government in any of our lifetimes. This is not a policy dispute. It is a fight over who controls the machinery of government, and both sides believe they will win. Subscribe, because the next update drops the moment something breaks, and based on what sources inside both camps are saying, that moment is coming fast. Here is where things stand. Witness 14 remains in custody at an undisclosed federal location. His attorneys filed emergency motions, and Caldwell has refused to hear them. The government's formal response is expected within 72 hours. The Vice President scheduled a major address on judicial accountability later this week, described by staff as historic. Caldwell is reportedly consulting other judges about coordinated responses to executive pressure. And here is what is not in the reports. Sources say the administration has identified the 2 advocacy organisations that communicated with Caldwell's chambers. They are building a case, and they plan to go public before the Vice President's address. Watch for announcements of judicial ethics investigations in the next 48 hours. Because if they come, it means the administration is done playing defence and is moving to offence against sitting judges. The clock is ticking, and what happens in the next few days could reshape how government functions. But what keeps me up is this. JD Vance is moving right now. It looks like righteous anger. It looks like a government finally pushing back. But stories like this rarely end clean. That background voice saying, "The list worked," is still unidentified. Witness 14's exact location remains unknown, and a rumour in Washington will not die that Caldwell has documentation of his own, something that explains his actions, something that would flip the narrative if it surfaced. Is that real, desperation, or disinformation meant to make the administration hesitate? I do not know yet, but I know this. Whatever happens next is going to be bigger, darker, and more explosive than anyone is predicting. Because it stopped being about one witness and one judge the moment that audio hit the outside world. This is now about who controls America, the people who win elections or the people who never have to. The only question is whether you will be watching when the answer becomes clear. Because when this breaks, and it will break, I will be here. And trust me, something is about to.